Hello everyone and welcome to the Lawyer Talk, a podcast by BLawyers Vietnam. I am Dang Thi Kim Chau, and in today's episode, we are discussing a topic that is becoming increasingly relevant for business in practice: AI and the law. AI can help business work faster and more efficiently, but what legal risks come along with it? Today, AI is being integrated into almost every aspect of business operation, from internal management and customer service to recruitment and data analytics. However, along with this rapid adoption come very real and practical legal questions that many businesses are still not fully prepared for. That is also why the topic of AI and the law is becoming more and more important. First, if AI causes harm to customers, business partners, and our user, who will ultimately be legally responsible? Second, how far can a business go in using data to train AI, and where is the legal line it should not cross? From the perspective of AI and the law, this is no longer just a technology story. It's also a story about legal responsibility, data ownership, personal data protection, and how business manage risk when they bring AI into their operation. In particular, under Law on Artificial Intelligence 2025, or AI Law 2025, together with the Law on Personal Data Protection 2025, or PDB Law 2025, and related regulation, businesses using AI are no longer seen merely as users of technology. They may should be treated as the party responsible for the risks created by the AI system. So if your business are already using AI or planning to do so, what legal risks should you be spotting early? That is exactly what we are discussing today. The first question: if AI causes harm, how might a business be held legally responsible? This is one question we hear quite often from business. If AI learns on its own, analyze information on its own, and then make the wrong decision, does the business still have to take responsibility? Legally speaking, at least for now, AI is not treated as an independent legal person that can stand on its own or appeal liability by itself. So when an AI system causes damage, the real question is usually not whether the AI worked wrong, but who developed it, supplied it, deployed it, controlled it, or used it. Under the approach taken by the AI Law 2025, responsibility is allocated based on the role each party plays in the AI scheme, including AI developer, AI provider, deployers, and user of AI system. More specifically, responsibility may be allocated in the following way. First, for AI developer, liability may arise if the problem comes the algorithm, the training data, the system design, or technical features that do not adapt quickly and ensure safety. Second, for AI provider, obligation may include risk assessment, transparency, user guidance, and coordination in handling incidents under relevant requirements of the AI Law 2025. And third, for the developer or user of AI system, liability may arise during operation, supervision, incident logging, notification to relevant party or competent authority, and the handling of consequent causes by the AI system. In practice, many businesses are currently using third-party AI tools such as AI chatbot, data analytics tool, or AI recruitment system. But using the third-party service does not ultimately mean the business is off the hook. For example, if a business uses AI to screen job applications, but the system produces discriminatory outcome or mishandle applicants' personal data, it will be difficult for that business to simply say, "That's where AI fault." In many cases, legal responsibility may still come back to the developer, the provider, or business deploying the system. But simply, AI may support the human decision-making, but legal responsibility usually does not stop with an AI. In the end, responsibility still tends to come back to the people, organization behind the developer, supply, and use of that tool. Second question is how far can a business go into using data to train AI? First, here is a very practical question many businesses are asking. Can a business use email, image, transaction data, or customer data to train its internal AI system? In the AI era, data is almost the raw material that helps these systems perform better. But that does not mean a business is free to collect any data it wants, feed any data into AI, or reuse all data for any purpose it chooses. This is basically important. Note that the BDB Law 2025 took effect on the 1st January 2026 together with the guiding regulation under Decree number 365 and the Decree number 142. In that legal context, the collection, processing, and use of personal data, especially in technology and AI environments, need to be approached much more carefully. As a general principle, personal data processing must meet several basic requirements, including: firstly, there must be an appropriate legal basis for collecting and processing the data, such as valid consent from the data subject or a proper agreement between the data controller and the data processor. Secondly, the data must be used the purpose that the data subject agreed to. Thirdly, consent must be obtained in appropriate form and must meet legal validity requirements under Personal Data Protection Law. For data used to develop or train AI, Article 35 of Decree 142 also sets out an important principle. Organizations and individuals may only exploit and use the data for AI development within the scope, purpose, and access conditions that have been publicly disclosed or contractually agreed. In other words, the issue is not just whether the business has the data. The more important question is whether the business has the legal right to use the data for AI training. When it comes to sensitive personal data, business should generally take a strict approach and limit its use for AI training as much as possible. The kind of data should be used in only when it is truly necessary, supported by a clear legal basis, packaged by valid consent, whether required by law, assessed for risk in advance, and protected by appropriate security and control measures to reduce the risk of data leakage, reverse inference, or re-identification. In practice, many businesses are now tending to: first, collect data at large scale. Second, use publicly available data on the internet. And third, apply the customer data to third-party AI platforms. That leads to another very common question. If data is publicly available on the internet, does that mean a business is free to take it and use it to train AI? The short answer is not necessarily. Under Spirit Decree number 142, the implementation and use of AI must not infringe: first, the data ownership right of the individual; second, intellectual property right; third, privacy right; and fourth, the lawful right and legitimate interests of relevant organizations and individuals. That means even if data can be accessed publicly, business still need to review the source of the data, the access condition, the lawful term of the use, the right of data subject, and the purpose of which data is being fed into the AI system. Another point worth noting is data anonymization. Under Article 36 of Decree 142, a business may still face a liability if AI system can re-identify an individual from anonymized data, or if the data is combined with the other sources in a way that reveals a person's identity. So the biggest risk is not always that AI trained on the too little data. Very often, the real risk is that a business does not yet clearly know which data it is allowed to use, which data it should not use, and what purpose that data may be used for, and how the AI system is actually processing it. Finally, I think business should do right away when using AI. Based on the issue we have just discussed, business can start by prioritizing these 5 areas if they want to use AI effectively while still keeping legal risks under control. First, review contract and responsibility allocation with AI provider, especially term on service scope, safety standards, allocation of liability, limitation of liability, indemnity, and incident handling. Second, control data sources and the purpose for which data is used in AI, including identifying the type of data involved, the right to use it, the intended purpose, access condition, and any relevant legal restriction. Third, limit the use of sensitive personal data or confidential information in AI, unless there is a legal basis, valid consent where required by law, approachable security measure, and effective control to reduce the risk of re-identification. Fourth, maintain the human review and oversight over AI outputs, especially in high-risk areas such as recruitment, finance, insurance, healthcare, education, customer service, or personal data processing. Fifth, build an internal policy or rule book for AI use, clearly setting out which AI tools are allowed, what type of data may or may not be entered into the AI system, which case require prior approval, what responsibility staff members have, and what process apply when incidents arise. In short, when business talk about AI in the law, the question is not only what can AI do, it's also what an AI allowed to do, what data may legally be used, who is controlling the output, and who will be responsible if something goes wrong. We have worked through the scar issue many businesses are now facing as they adopt AI, from the responsibility when AI causes harm, to the limits on using AI for AI training, and the practical steps business can take to manage risk from the start. We hope today's discussion gives you a more practical view of AI and the law when implementing AI in the business operation, especially from the perspective of legal compliance, personal data, and risk management. If you are interested in AI and the law, you are still considering how your business can use AI in a lawful and safer way, feel free to leave a comment so that we can continue the discussion in future episodes. And if you would like to learn more about BLawyers Vietnam, we can find more information in the introduction session of the Lawyer Talk. Thank you for listening and see you again.